Thank you, Judge. Mr. Engel?
Sure, thanks. Thanks, Mason. Just picking up maybe where the judge left off, Guantanamo is a problem, I guess, without end, or the circumstances that we face here 10 years into, whether you call it the war on terror or armed conflict with Al-Qaeda, Taliban, etc., is a difficult problem because we are in a law of war framework that permits indefinite detention, and which is understood as detention for the duration of the hostilities. But in this war, it's not easy to tell when, if ever, the emergency will end or the hostilities will end. Certainly, we're still in Afghanistan now. We may well be in Afghanistan for a number of other years. It's not clear that if and when we leave Afghanistan that the threat from Al-Qaeda won't persist in other places, because the terrorist group seems to pop up in one place after another, whether the Horn of Africa or Yemen or Iraq or the like. And under those circumstances, and I should say occasionally in places in Europe or the United States as well, so long as the United States considers itself under a serious threat from an organization with the capacity to project real harm, it will be difficult for judges and it will be difficult for policymakers to make a determination that it's safe to release these individuals. And the law, at least as set forth in Hamdi and under the law of war framework from prior Supreme Court precedents, permits such detention. So I don't know that there's a better answer than where we are now. And perhaps there are ways to evaluate that either courts or policymakers can evaluate this thinking in time. But at present, I think folks are left with unappealing options, and the unappealing options is that it's more unappealing to let some of these folks go, and we have the legal basis to hold them, than it is to come up with some other framework. But I think I worked on Guantanamo issues during the last 3 years of the prior administration. I left January 20th, 2009, as the new administration was coming in, and it is interesting that we probably could have had this panel 2 years ago and had many of the same discussions that we're going to have here. We could have had it last year too. We have a situation in which there has been, actually, I would say, an emerging bipartisan consensus with respect to these Guantanamo issues, which no one may be happy about, but I think exists. It may not be the bipartisan consensus which some folks in this room, feel, or the place where they would be, but we have a situation in which the United States government, through 2 administrations, which disagree on many things, have reached, I think, fundamental agreement on a series of legal policy propositions. The United States is at war against Al-Qaeda. The law of war detention framework applies. Guantanamo is a concept that has proven controversial, particularly abroad, and sometimes at home, is a facility that ideally would be closed. On the other hand, as of yet, the Obama administration, no more than its predecessor, has found itself unable to come up with an acceptable alternative to housing the detainees there. President Obama tried. It appears that he has been unsuccessful, and we have not heard his administration pressing it much lately. At present, Guantanamo is a safe and humane facility, and again, it may be the best of among unappealing alternatives. In addition, and perhaps this is surprising, but the Obama administration has adopted and to some extent amended and improved the military commission system, which was set up by President Bush and then by Congress in the Military Commissions Act of '06, which was essentially reenacted with some improvements and some other amendments in 2009. And so we have a system in which, through 2 administrations, the United States has committed itself to using alternatives to the Article III courts for the prosecution of war crimes. Now, all of this we could have said a year ago in describing where the Obama administration stands, and I think folks have said that a year ago. Since President Obama was less committed, or is less committed, to the military commission system for some cases than was the Bush administration. the Bush administration, by and large, determined that with respect to folks at Guantanamo, with respect to folks we are being detained as enemy combatants, unprivileged belligerents, whatever you want to call them, the military commission system was the appropriate criminal forum for prosecution. President Obama's administration has been a bit more nuanced or I should say, Article III courts are available for, according to the Bush administration, for terrorism cases, but they were terrorism cases in which individuals were picked up by the FBI, often domestically, rather than people who came into United States custody through military intelligence sources or through foreign governments. The Obama administration has taken the view that while military commissions are appropriate for some cases, they will go through a case-by-case review with respect to folks, even at Guantanamo, and determine who will get Article III prosecutions, who will get military commissions. I think I think they have been less successful in articulating clear standards as to who goes where, and I think they've run into difficulties because largely, absent some kind of clear demarcation, you're left with the appearance that the folks at Guantanamo who go to Article III courts are the folks for whom there's admissible evidence to be prosecuted in Article III courts. And the folks who go to military commissions are the folks for whom there's less admissible evidence to go to Article III courts. And so, in a sense, they get due process light in the commission system. I don't think that has to be the perception, but I think that by doing this case by case without clear standard evaluation of the detainees, the Obama administration generates that perception. As a result, and I'm getting posted, so I will move to what Mason asked me to talk about, which is the executive order, very quickly. But as a result, since the White House overruled the Attorney General's decision to prosecute the 9/11 case in a New York federal court, the Obama administration has done very little outside of its work in the courts to advance the ball on Guantanamo Bay. We still don't know where the 9/11 case will be tried. We still don't. There have been no new military commission cases filed over the last year. And as we heard last week from the administration apparently has no detention policy in place for Osama bin Laden or Zawahiri or any other high-value al-Qaeda detainees who may fall into our hands, at any moment. It's disappointing. I think to some degree it's alarming. I think it probably reflects internal disagreement within the administration that has paralyzed the policy process. It may also reflect the decision not to touch these issues prior to the election of November 2010. Hopefully, there are signals that we will now move forward, or that the Obama administration will move forward with the Guantanamo cases, both with respect to new military commission prosecutions and with respect to the executive order that's being contemplated. Just to be clear, an executive order is nothing more than a determination within the executive branch. It's an order from the president to his subordinates in the executive branch. It can't create any powers. It can't justify detention. Rather, it informs folks within the administration as to the standards and the procedures by which they will go forward with a detention. The Bush administration had a similar process in place within the Department of Defense with respect to Guantanamo detainees, where individuals were reviewed administratively on a year-by-year basis to determine whether the cause for holding them, their membership in al-Qaeda, etc., and the threat that they might pose for recidivism if they were released, whether that would continue. By accounts, the Obama administration is considering a more robust process. I think it's overall a good thing. There's no reason not to consider to review the cause for holding folks who we intend to hold for a long time. On the other hand, I actually think in practice, if you're talking about individuals who have previously been determined by the administration to be held, who will survive, by definition, habeas challenge in the federal courts, I don't think there are going to be that many individuals who will then be found, at least in any kind of a reasonable time period, through this executive order, this review process, to suddenly be people who we no longer want to hold. I think these folks have been well vetted, and in many cases, individuals are avowed jihadists, and so it just seems like a good idea, but hardly a solution or something that's going to significantly trim the problems of indefinite detention in the future. But I think I've overstayed my time, so